welcome to everybody. Today, Nikki and myself will be taking you through some of the issues that are asked by suppliers and also by consumers. We will look at what the CPA's provisions are in relation to those questions. But Nikki, who deals with the day-to-day complaints, will give you some of the unique examples that relate to those cases and how the CGSO has responded to them. So how we are going to go about this is that I'm going to go through a presentation which contains the questions and the provisions themselves. And Nikki and myself will have a discussion about some of the issues. And like Omar has said, you are welcome to post your questions on the chat box, and we will try and respond to them today. There are so many questions that today will be the first of the webinars where we address some of the questions. We are going to arrange other webinars to address some of the frequently asked questions that we receive in our office. So if you will allow me, I will put up my presentation and then I will go through it today. Thank you so much. Oma, is it in presentation mode?
Yes, it is, Mahauta. Thank you.
Thank you so much. So what I thought I would do before we go into the questions themselves is just to give you an idea of the complaints that we as an office has dealt with from March last year. Our financial year end is February, so we started this. These statistics are from March last year up to the end of January this year. So in terms of calls and emails that we've received in the office, we've received to date 16,735 calls and 8,805 emails from consumers. We received 10,924 complaints, which is a bit of a drop of about 15.5%. And we closed 13,000 cases, which is an increase of 10.5%. So it means we are closing more cases than we are receiving, because last year, because of the pandemic, we were really flooded with complaints. So our caseload was quite high. The outcome of complaints in 58.1% of cases, the outcome was in favor of the consumer, which means that consumers received exactly what they were expecting out of the process. Our average days to close cases was 64 days. In case of the code, we have a maximum of 60 business days in which to close a complaint. But as things go, some cases are complex. In some instances, suppliers take quite a long time to respond, and consumers themselves are sometimes guilty of submitting a complaint, but not following through when they have to respond to some of the issues that arise out of the cases. We were able to recover 10.5 million in refunds and other forms of redress for consumers. 91% of our cases are received through the website, and we prefer that because we have a page on the website where you can lodge your complaint. And since the lockdown, that has been the preferred method for many people. There are those who don't have access to internet or data. We do assist them through our call center, and we're also able to send them information. We receive our complaints from all the provinces, with 49% of them being from Gauteng, 18% Western Cape, 13% KZN, and the other percentages from the other provinces. But when we look at data across, even when you look at access to credit, Gauteng, Western Cape, and KZN seems to be the key economic hubs in South Africa, and generally they attract a lot of these issues. Most of our complainants are aged 18 to 39, followed by 40 to 59, and then the other age groups. If you look at the types of complaints that we receive, top of them is not on time or reasonable. This relates to the delivery of goods or services. Then it's followed by cancellations, defective goods within 6 months. As you know, consumers have a 6-month warranty within which they could receive a refund, a replacement, or a repair. There are a lot of complaints also about the complaints resolution process of suppliers. Can everyone please mute? Thank you. Where the internal complaints handling process of the supplier is not working efficiently. For example, a consumer will come to us and said, I emailed, I telephoned, I sent a message on the Facebook page, but still there has been no response. Then there's issues relating to overcharging, cancellations relating to the lockdown itself, and so on. And when we look at the complaints by sector, online transactions are top, and that is understandable because of the lockdown, sectors were forced to move to online transacting, and they've been trending since the lockdown started. Then it's followed by telecommunications and satellite services. That is your cell phones, your subscription services, electrical appliances, cell phones, furniture, and so on. So, and the other thing I wanted to explain before I go into the questions is that it is important for people to understand our jurisdiction when it comes to the resolution of complaints. Our code of conduct requires us to have regard to fairness, justice, equity, and the provisions of the CPA and the code. And what that basically means is that, yes, we will look at the provisions of the Consumer Protection Act and our code of conduct, but we will also look at the circumstances and the merits of the case in relation to fairness. So this means that we might not necessarily limit ourselves to the provisions of the Consumer Protection Act, although we will take them into consideration. We are required to balance the rights of consumers and that of participants, which means suppliers in the industry. So we are required to be a neutral body that looks at the facts of the matter and make a recommendation to the complainant and the respondent. We are also required to look at the law, applicable industry code guidelines, and fairness in all circumstances. So we do not have decision-making powers. So we can only recommend to the parties. And in terms of section 11.7.4 of our code, neither a complainant nor a participant shall be bound to accept a recommendation made by the Ombudsman. So all our outcomes are because suppliers are agreeing to provide redress or the parties reach a settlement. If we are not able to assist the parties to reach a settlement, the consumer then, in terms of section 72 of the CPA, has to lodge a fresh complaint with the National Consumer Commission, which means that from our side, we have to terminate the matter on the basis that there is no probability of the parties reaching a settlement, or that the supplier has not agreed to provide redress because they are not wrong in terms of the CPA. So there has not been a contravention of the CPA. This does create some frustration for consumers to say, why don't you have decision-making powers? Why do I have, after 3 months of my complaint sitting with you, have to go to the National Consumer Commission, which also further delays access to redress? Unfortunately, that is currently how the Consumer Protection Act is drafted in that the first escalation after you try and resolve with the supplier will be ourselves. And if we fail, then it will go into the formal process where the NCC can investigate the matter and then escalate it to the National Consumer Tribunal, who is the only body and the courts that can then make a binding decision, either in terms of forcing some kind of redress or administering an administrative fine. Now, let's come to the questions. The first question that is very common, and this relates mainly to gym contracts and cell phone contracts, is that when is the cancellation of a fixed term agreement effective? For example, complainant cancels their contract during the term, giving 20 business days notice. Then the supplier provides a cancellation fee, but the complainant doesn't pay it or disputes it, because as you know, the CPA says that if the consumer cancels before the end of the fixed term, the supplier is entitled to charge a reasonable cancellation fee, but that reasonable cancellation fee is not provided for in the CPA guidelines are provided as to how that cancellation fee must be determined. And we do receive a lot of complaints relating to the cancellation fee that has been asked. So what is happening is that some suppliers are saying they deem the agreement not to be cancelled, and what they do is that they continue to debit the consumer for the contract and the services, even if the consumer is not using them, until the cancellation fee has been paid. That is the only time that they cancel. So in relation to this question, to say when is the fixed term agreement, the cancellation effective? When the consumer gives notice, remember it's 20 business days notice, which is effectively a month. After that month, or only after they have paid the cancellation fee. This one, we will look at section 14, which provides as follows: despite any provisions of the consumer agreement to the contrary, the consumer may cancel that agreement upon the expiry of its fixed term without penalty or charge, but subject to subsection 3. Now, subsection 3 is the one that then speaks about the cancellation, the payment of the cancellation fee, and at any other time. And the supplier, remember, can only cancel the agreement if the consumer is not has breached the contract and they have failed to remedy the breach after being given 20 business days notice by the supplier. Now, 14.3, it says that upon cancellation of a consumer agreement, the consumer remains liable to the supplier for any amounts owed to the supplier in terms of that agreement up to the date of cancellation. So that means up to the time that the consumer has provided the supplier with a notice that they wish to cancel. And so up to, after that 20 business days, up to that period, the consumer remains liable to the supplier for any amounts owed to the supplier, including a cancellation penalty if the cancellation was before the end of this fixed term. So we've spoken about that review. So I'm going to give over to Nikki to then talk about how we have
Hang it on the blue white line, that one.
Sorry? I'm going to give over to Nikki to speak about how we have dealt with this question in the complaints that we have received. Nikki?
Thank you, Magauta. Morning, everyone. We often receive complaints on this topic, and essentially the agreement where there becomes possibly a misunderstanding from certain suppliers is that the contract does not end once all amounts have been paid. As you said, when the complainant or consumer sends their notice of cancellation or giving 20 business days notice, on the expiry of the 20 business days, that is when the contract expires. So the consumer is liable for any amounts or arrears that are owing as at that date of cancellation, as in, for example, 20 business days ends in the end of January, for example. So the consumer in that instance would be liable for any amounts that are owing as at that date, if any, or a reasonable cancellation fee. And if the consumer is disputing the amount of the cancellation fee and saying that it's too high or unreasonable, that doesn't give a window of opportunity for suppliers to say, well, therefore the agreement has not been cancelled until we receive payment of whichever cancellation fee that has been quoted. So please bear that in mind, because what is happening is that suppliers continue to debit. So if the agreement had deemed to be finished at, say, the end of January, but the consumer hasn't paid the cancellation fee or the arrear amount that's owing, or both, then the certain suppliers will continue debiting and saying, well, the agreement isn't cancelled, hasn't been cancelled, and they'll continue to debit for all the months. So it could land up, I mean, if the dispute is sitting in our office, or the complainant is dealing with the suppliers dealing with the consumer, the contract cannot continue to accrue arrears, because often times consumers are cancelling because of financial difficulties. And so essentially the agreement is finished after the 20 days notice, and in that time, just by the way, the consumer may continue using the services during that notice period. Thereafter, any amounts that are due can be claimed, but in that instance, the supplier would need to follow collection steps through collection agencies or attorneys, but cannot continue to debit after the expiry date.
Thank you, Nikki. And I think that is important from a fairness perspective, because like Nikki has said, consumers a lot of the time would want to cancel a gym contract or a cell phone contract, either because of affordability, or like me, they are not using the service at all. So it is important for the supplier to cancel when the notice period expires. And if the consumer, for some reason, does not pay any amounts outstanding, and then follow a collection process. Because what we've seen is that not canceling it at that point because of a dispute about the cancellation fee or any arrears is that it does create a serious hardship for the consumer, because and it also, I was owing you 300, but because you continued, I'm now coming back to the CGSO to say, I tried to cancel, but now I'm sitting with a 6,000 rand bill, which definitely a lot of consumers cannot afford. So our view is that it should be cancelled when notice is given. The consumer does remain liable for valid and agreed upon fees. And if there is a dispute between a supplier and the consumer, and you cannot resolve it, please refer the consumer to the CGSO rather than leave the matter, and then the consumer comes to us 1 year later and they are sitting with a huge bill which they cannot afford. Thank you, Nikki. Now, so you will keep on posting your comments or your questions. Thank you. And remember, like I said, I mean, the law, no one ever has the same interpretation. And the code does allow you, if you don't agree with us, to then say you will not provide the redress and escalate it to the, advise the consumer to escalate it to the NCC, which is what we will do. The next question is who is responsible for notifying the other party that their contract has come to an end? So what we consumers are complaining about is that some gyms have a term in their contract in which they place the burden on the consumer to cancel at the end of the term, failing which the agreement continues for the fixed term. So it would, if it was for 1 year or 2 years, it would then continue for that. But also section 14 then deals with that. It says that of not more than 80, no less than 40 business days before the expiry date of the fixed term of the consumer agreement, the supplier must. It doesn't say the supplier may notify the consumer in writing or any other recordable form of the impending expiry date, including a notice of any material changes that would apply if the agreement is to be renewed or may otherwise continue beyond the expiry date, and the options available to the consumer in paragraph D. So the option is whether to renew or to terminate. On the expiry of the fixed term of it will be automatically continued on a month-to-month basis, subject to any material changes of which the supplier has given notice. So you still have to give notice as contemplated in paragraph C, unless the consumer expressly directs the supplier to terminate on the expiry or agrees to a renewal of the agreement for a further fixed term. We all know, those of us who have gym contracts or cell phone contracts, I've had a cell phone for years. I've never received notification that my contract is coming to an end and that I have an option to terminate or renew for a further fixed term. What you get is marketing that, no, we have this beautiful cell phone, you are due for an upgrade, you are a very good customer, please process the upgrade. So basically what is happening is that suppliers are breaking the law. They are definitely, what we've seen, they are not providing that notification. Instead, they market to the consumer so that the contract can be renewed. And all of us, like me, we love beautiful cell phones. So what do? We continue to renew. But it happens that some consumers forget that they have a contract that they have to cancel. So Nikki will take over and talk to some of the issues and how we've resolved them. Thank you, Nikki.
Yes, thank you. It's not only that some consumers forget but others don't think that there's a responsibility on them to cancel because they think, well, my contract is finished in 24 months and then it's done, I'm out. And we're getting a lot of, we receive a lot of complaints, again, gym contracts and cell phone contracts, where complainants will come to us and say, well, my agreement expired, but I'm still being charged. We will then escalate to the supplier and say, please, will you send us your section 14 notice? I can't remember in all my time at the CGSO when I've seen one section 14 notice from a supplier to say, we gave them notice to say, your agreement is coming to an end. Please say yes or no. Do you want to carry on or is it finished? So just for instances where notices are not sent, which seems to be the majority of cases, well, if not all, that we've received, that agreement comes to an end on its termination date. It does not continue to run on a month-to-month basis. Only where the notice has been sent and the consumer keeps quiet and doesn't say, please terminate or please renew, then it will carry on a month-to-month basis. But in the absence of any communication from either party, but specifically the section 14 notice, the agreement terminates on its expiry date, and then suppliers are not entitled to debit any further fees on that contract.
Thank you, Nikki. I think one other issue that we've dealt with is where the contract does continue on a month-to-month basis, and when the consumer wakes up and wants to cancel, we've had a few suppliers that have said they want to charge a penalty. If it's on a month-by-month basis, the consumer has a month to give notice, nothing else. And if they've given notice, there are no penalties except for any amounts that they are owing to the supplier at that time. Is that correct, Nikki?
Yes, I think that's correct.
Okay, thank you so much. All right, that's that one. And then we get this one where suppliers are saying consumers are abusing us. They are getting requests for compensation for travel. However, they feel that they should not pay the compensation for travel when the consumer is returning goods to them, because anyway, the consumer is coming to the mall. So why must I pay them? Because they are coming to the mall anyway. So they think that that is abuse. So the CPA does cover instances where the return of goods are at the risk and expense of the consumer, and when the return of the goods should be at the expense and risk of the supplier. So, and the section that deals with that issue is section 20, which provides as follows. Goods returnable in terms of the cancellation of a direct marketing contract must be returned to the supplier at the consumer's risk and expense. So if I'm sitting here at home, and like it happens all the time, even now as I'm talking to you, there are calls coming through my phone where I'm being sold a variety of either goods or services. And if I agree that I'm taking out a cell phone contract and you called me and you deliver that cell phone contract, and then after a day or so, I decide that, Mara, I hadn't budgeted for it. Maybe I felt under pressure to take on this cell phone. Like yesterday, I said to some cell phone company, please, I'll think about it. Call me on Monday. But sometimes you don't say that, you accept it. But after then you do your maths and you see, no, I should not have agreed to this contract. So for me to return that, it is my responsibility because I am the one who changed my mind about that transaction. We agreed. So the return will be at my risk and expense. However, if you under certain circumstances, it is the goods must be returned at the supplier's risk and expense. And that is why you will find a lot of suppliers, and especially for big ticket items, will come and collect and not charge the consumer anything, because that is what is required in terms of the Act. So if goods are returned because the consumer did not have an opportunity to examine them before delivery, and the consumer has rejected those goods, then the return is at the supplier's risk and expense. And this happens quite a lot currently with online transactions. I'm sure all of us have those funny moments where you see, like us ladies, you see a nice handbag, you think it's a handbag. When it comes to you, it looks like a purse. And we've seen even on social media, some people joking about what they ordered and what they actually received. So in those instances, you did not, as a consumer, had an opportunity to examine the goods. So when you receive them, they are not what you ordered. They were not what you saw on the catalog in that instance. And that is why you will find that a lot of online retailers would then fetch the goods because you did not have the opportunity to inspect them. It's also where a mixture of goods were sent to you. So basically the wrong goods. You ordered 2 items, 1 item was correct and the other was not, and you refuse delivery of the whole thing. Then the return will be at the expense and risk of the supplier. Goods intended to satisfy a particular purpose that was communicated to the supplier. So in these instances, we usually receive complaints for somebody who said, I went to a computer shop, I told them that I want or maybe even online, I wanted a computer that can do 1, 2, 3, 4, but when I received it or when I took it home and I tried to use it, it did not meet the purpose for which I had communicated to the supplier. In that instance, the return would be at the risk and expense of the supplier. So, I mean, we know that practically it's a difficult one, but in those instances, the supplier is responsible for the expense. It could either be courier costs or it could be a taxi ride or something like that. Some suppliers give vouchers and some don't like giving the expense for the travel. And we also thought it is important to indicate under what circumstances a consumer is allowed to return goods and where the supplier is obliged to deal with that return, because we also have a misconception in the market by consumers who think that they can return anything even when they change their mind or they've bought the wrong goods. So consumers are only allowed to return goods when they are defective, when the goods are bought from a catalog online or something where they did not have an opportunity to inspect the goods and the goods do not fit the description. And we have said to online retailers, make sure that you give a full description of the goods, and if it even has to include dimensions in terms of size and so on, please do that, because when you don't do that, the consumer has a perception that this thing is this big or it looks this way or this color or it contains these components. And when they receive them, they said that this is not what the catalog described. It only showed me a nice picture. So it's quite important for the description to be correct to minimize disputes. But in those circumstances, if the fit do not fit the description in the catalog, the consumer has the right to return them. And then goods that the consumer did not have the opportunity to inspect and they do not fit the consumer's requirements, goods that were bought in terms of direct marketing and they cooled off within 5 days, goods that were delivered not as per order. So that's where the CPA allows consumers to return goods. But if a consumer goes into a shop, they fit, they take the wrong size, or if they go into a shop, they just take a computer from the shelf, and then when they don't communicate to the supplier what they want to use that computer for and whether it has the features that they are looking at, or just in the buyer's remorse, like us, Bo Magauta, when you are depressed, you go and buy a nice dress and the next day you decide, Mara, I should have had a glass of wine instead of buying this dress. Let me return it. No, the supplier is not under any obligation to accept that return. So that would be subject to the supplier's own internal refunds policy for change of mind purchases. So, you know, some suppliers will give you a receipt and say, please return within 7 days with the tag on or with the packaging intact, not tampered with. That is up to them. That is not regulated by the CPA unless it's under these circumstances that I have outlined. So we do have a lot of complaints where consumers said, I bought some pump for my tap, and when I got home, it did not fit. In those instances, you can even be charged a handling fee, but we will deal with handling fees, I think, in the next webinar. So what we've done for you here, we will share this presentation. It outlines cancellation timeframes, risks, and penalties, and the relevant sections to say, when can you cancel? What are the time limits? What are there any penalties, costs, and risks? If it's a franchise agreement, you have 10 business days of signing, and there are no penalties. Fixed term agreements, we've said there are reasonable penalties that can be charged, and you have to give 20 business days notice. Advanced bookings, reservations, and orders. This was a big issue during the pandemic because, as you know, a lot of people had to cancel flights, weddings, and so on. There are no time limits. It would be in the terms and conditions of the supplier, and a reasonable penalty is allowed. Direct marketing, we've said 5 business days, no penalty, but the return to supplier is at the risk and expense of the consumer, and the goods must be in the original packaging. If they've been tampered with here, the packaging, you can charge a handling fee. Goods delivered other than as agreed in terms of time, quality, or not for fit for intended purpose, 10 days, within 10 days of delivery, the consumer can return to the supplier. There is no penalty and it's at the supplier's risk and expense, but under certain circumstances, they may charge for use or handling. Services of poor quality, the consumer has the right to receive the service in a timely manner at the agreed place and of the quality that is expected. If not, they are entitled to a refund. Goods delivered defective, not durable. We know there is a 6-month warranty from delivery. There is no penalty unless the goods returned without penalty at the supplier's risks and expenses. And of course, if the consumer has tampered with the goods, they cost the damage after receiving the goods. We have a lot of disputes around those issues, especially with regards to cracked television screens, where consumers say, I took delivery and they had and they inspected the television, and then when they get home or after a few days, there is a cracked screen and they claim that it was cracked. So we have to deal with those issues, and sometimes we have to call in inspectors to inspect the goods to determine who created the damage. And then laybys, you know, some of us do forget laybys, but there are people that are taking laybys, and not more than 1% if the consumer decides to cancel the lay-by. We had a lot of lay-by cancellation recently when there were riots, because the goods that consumer had put on lay-by were either were destroyed, and some suppliers were not willing to refund consumers. Okay, Nikki, do you want to speak to this issue and some of the complaints that you've dealt with regards to compensation for travel?
Yes, I think we've gone back to the previous slide.
Okay, should I go back to it?
No, it is on the, if we can just go one forward.
Next. No, it's not this one.
We talking about the receipts.
No, we are talking about the request for transport money when the consumer has this one, when the consumer has to return the goods.
Yes, I think as you've quite rightly set out there, of the sections do speak to who's responsible or whose risk and expense the return is at. And we do get a lot of suppliers to say the consumer came in and he wanted his petrol money and he wanted this. Well, if the return is at the supplier's risk and expense in terms of section 20, I think it's 2B there, the setting out where it is at the supplier's risk and expense, the consumer should be compensated for the courier fee, for example, or their petrol. It's a bit tricky to quantify when it's a petrol claim, because you don't know how far the person's been coming from. So we would suggest that a voucher or some form of compensation would be due in instances like that. Obviously, as I said, if it's a courier fee, on presentation of a receipt or a bill from the courier, that amount should be refunded by the supplier. With petrol claims, it's a bit harder, but more difficult to quantify. But and thank you to those suppliers who are giving vouchers. That goes a long way to making consumers feel a little bit better. But those claims are for the supplier's risk and expense, so a complainant should be refunded for their costs to return the goods in those circumstances.
What about those of us who say, they wasted my time, I had to telephone them 20 times, send them an email, I want them to compensate me for that?
I think okay, if one can quantify all of this, but strictly speaking, time and energy and what inconvenience it was, that's really consequential loss. So that would not be covered by the CPA. But in my view, if the consumer can say, well, I'm 10 kilometers or half an hour from the store and give a reasonable petrol claim, I think that should be reimbursed by the store.
Yes, thank you. And we do have a lot of consumers who do come to us and say, I want them to pay me for my time and so on. And unfortunately, we don't entertain that. We would only deal with the travel and the risk part. So consequential damages in some sections of the CPA are allowed, and sometimes you have to go to court to be able to claim those things because, like Nikki said, you have to prove and quantify them. And that is not what this section intended. Thank you, Nikki. Oma will share this presentation with all of you, so we will be happy to share it. Now, the other question that we received, especially after the recent riots, and we know that some of our participants and suppliers did indicate that they will not take back items if there is no proof of purchase. But and we do have customers that feel that it's the shop's product, then any store should they should be able to prove that it was bought in that store, and they should be able to return it in anywhere, and they must take it back, even if that store, because as you know, a lot of our big suppliers are chain stores and can be accessed in different towns and provinces. So they want to return anywhere, and even if the store doesn't stock the product. So Section 26 of the Consumer Protection Act requires that consumers must be provided with a record of the transaction, which basically is a till slip indicating the date, the item bought, and the price for which the item was bought. But it doesn't make reference to till slips being required when goods are returned. But our view is that a reasonable person can read into the section that why would the Act require you to be given with a record of the transaction if it's not going to be used? So even though the Act does not prescribe what it must be used for, our understanding is that a record of the transaction is necessary so that if there are any after sales issues, there needs to be a record so that it's not one word of the consumer against that of the supplier. And there are other instances where redress is tied to time limits. For example, we know that the CPA implied warranty is only for 6 months, and some store refund policies are also time-based. Like we've said, the voluntary return policies would say return within 14 days. So if you say return within 14 days and the consumer does not have a record of the transaction, are you obliged to take back those goods? Our thinking is that no, there should be a record of the transaction, and consumers also have a responsibility to keep record of transactions in case something happens, because the Act is not only one-sided. We have rights and responsibilities, and on this one, we think the consumer must play their role and keep receipts or any records of transactions that, or even agreements that they enter into. And like we said, change of mind returns where the consumer bought something and they decided it's not correct and it doesn't fall within the criteria that we've outlined in terms of when they can return, then it would be up to the store's policy whether they will take back goods and under what circumstances they will take them back. So we've said where the goods are not defective, where the consumer had the opportunity to inspect, then if they change their mind, the supplier is entirely entitled to say, I will take it back as is, or I will require a receipt. Anything to add here, Nikki?
And I think most of that, I think you've covered everything there.
Okay, thank you. Where's my thing now?
Magauta.
Hello. Post your questions, please. All right, the next issue is if the store runs out of stock for discounted items, they don't always have the funds to give rain checks. Customers even call to say they can't get there before the promotion finishes, but they want a rain check for when they can get there. Now, generally, suppliers are not obliged to keep items for consumers or to give rain checks. But the Section 30 of the Consumer Protection Act does deal with issues of availability of stock and advertising around that. And we get a lot of complaints, especially with regards to online transactions, where consumers complain that they will see highly discounted items, but when they try and buy, there is never stock available. And usually they demand that the supplier get stock and sell them at the discounted price. Now, Section 30 says a supplier must not advertise any particular goods or services as being available at a specified price in a manner that may result in consumers being misled or deceived in any respect relating to the actual availability of those goods or services from that supplier at that advertised price. So what this basically means, it talks to bait marketing. So you want to attract a lot of customers to your online store or to your shop, but you advertise fake prices and fake discounts. And when consumers get there, there is never stock. But when they get there, there is a very friendly salesperson who say, no, that one is not here. But no, they actually, don't you want to buy this one? And usually the ones that consumers are pointed to are sold at the normal price. So that is bait marketing. False advertising in relation to the availability of goods at a specified price. So if the National Consumer Commission would visit your store, you would have to provide proof. The supplier would have to provide proof that they actually did have those goods. And remember that you are required to then, if there is a limit, to indicate the limit. So 32 says that if a supplier advertises particular goods or services as being available at a specified price and the advertisement expressly states a limitation in respect of the availability of those goods or services from that supplier at that price, the supplier must make those goods or services available at that price to the extent of the expressed limits. So if you've said, guys, I only have 20 items at this price, a consumer cannot come back and say to you, you misled them and you must provide the goods to them at that price. But if you were to be investigated, you would have to prove that you actually had the 20 items that you had advertised at a discount. That is why a lot of adverts, you will say that a limited stock available is suppliers that are protecting themselves in case this issue arises. And then subsection 3 says it is a defense to an alleged failure to comply with the above sections if the supplier offered to supply or procure another person to supply a consumer with the same or equivalent goods or services of the kind advertised within a reasonable time in a reasonable quantity at the advertised price. And this is instances where within your limits, somehow you do not have the stock available. So Dinky, what is our view on this issue and what are some of the issues we've dealt with?
Thank you. Well, our view in terms of rain checks, some stores give rain checks if they were running a promotion and the consumers come to the store and they're out of stock of that particular item. The store may give a rain check to say you can still get that item for the advertised price after the expiry of the promotion. But obviously that's great, but there's no obligation on suppliers to hold keep goods aside for consumers or to provide rain checks. But as Magauta said, in instances where we receive complaints, where a complainant comes and says, well, such and such an item was offered for sale at this price. I went to the store, I tried to buy it online, and there was no stock available. We will ask the supplier in question to please provide proof that either the limit, as for example in Magauta's example, the 20 items were sold for that price, or that whichever item was advertised was sold for the price, and that will cover the defence to show that there was in fact stock, and not that in other words, to get around the bait marketing, because if stock was sold at the price, then it wasn't bait marketing. Magauta, I don't know if what's your view on this question. My personal view is when I've been to stores and there's a certain promotion running for purposes of section 33, if, for example, let's say it's a pack of something with 3 or 4 items in it are being advertised at a certain price, and the store doesn't at that point have stock of, say, the pack with the 4 items, but there are packs of 2 items. My view is that the supplier should, in order to comply with section 33, would be required to say, well, you, instead of the 1 pack with the 4 items in it, we can give you 2 packs with 2 items in it for the advertised price.
Yes, I mean, that's what section 33 says, unless if the consumer is then unreasonable. So the supplier can offer alternatives, and the consumer has to be reasonable in either rejecting or accepting the alternatives. But that is if they had not done any bait marketing. So if it's entirely up to the store. If they had 20, the 20 items are finished, but they want to maintain a good relationship with that customer, there's no legal obligation. The only legal obligation arises if it can be proven that they were indulging in bait marketing. They actually did not have stock of those items at that price, then they would be forced to then find alternatives for the consumer. Thank you, Nikki. Okay, another biggie that we receive is the price you see is the price you pay. Businesses say customers even move products or price labels and claim that price. Each price has a barcode on it to clarify, but people don't want to refer to that. What does the Act say about that? Section 23(6) says, subject to subsection 7 to 10, a supplier must not require a consumer to pay a price for any goods or services higher than the displayed price for those goods or services, or if more than one price is concurrently displayed higher than the lower or lowest price of the prices displayed. So that is where then the issue says you would have an aisle with barcodes and items. So according to supplier, a consumer would then move an item from a more expensive place where they were sitting to a cheaper place, and then they would say they are entitled to get the goods at that price. But we need, in this instance, we would then need to look at section 23(7). Subsection 6 does not apply in respect of any prices or services if the price of those goods or services is determined by or in terms of any public regulation. So which prices are determined by public regulation? Electricity, water, and so on, those are determined by public regulation. So this section will then exclude those prices. And then it says, if a price as displayed contains an inadvertent and obvious error, the supplier is not bound by it, but there are two conditions that they have to meet in order for them not to be bound by the advertised price. And again, this happens a lot on online platforms where incorrect prices are put up and consumers want to buy those items at the incorrect prices. So what happens when a supplier notices that they posted the wrong price, whether online or in store, they have to correct the error, and so two conditions, and take reasonable steps in the circumstances to inform consumers to whom the erroneous price was displayed that there was an error. And another thing is that, and Nikki will talk about it, there are a lot of disputes around this issue, where somebody is online, they transact, they pay, they receive confirmation of the order being received and payment being received, and the next thing the supplier comes back to them to say, sorry, that was actually an incorrect price. So that's where then the legalities come in. Okay, Nikki will talk about that. And then it says a supplier is not bound by a price displayed in relation to any goods or services if an unauthorized person has altered, defaced, covered, removed, or obscured the price displayed or authorized by the supplier. So here, this covers the question to say, if the consumer, who is not an authorized person, is a customer, he has not been directed by the supplier to change the price or move the goods to a different shelf and so on, then if that can be proven, then the supplier is not bound by that price. And this answers the question as to what happens if consumers move, if you can show that the place where the consumer found it and the barcode do not match, and the price is the same, then you are not bound by it, because that is illegal for consumers to unlawfully alter, deface, cover, remove, or obscure prices. Nikki?
Thank you. Yes, I think in the instance of the 2310, where prices are moved, what is of great assistance there is the barcode, because a lot of times the consumers don't look at the barcode, but they'll just swap such and such kettle with such and such kettle price. Meantime, there's a barcode that ties in with the product, and that easily will show that it's the wrong price for the wrong item.
Okay, so let's talk about the ones where, and we've received a lot of those, especially with online transactions, where the transaction and the payment was confirmed as being received.
Yes, consumers, we receive lots of complaints, primarily online actually, where consumers say they saw an Apple phone and it was 299 Rand or even 2,999 Rand, and they clicked and it went in the cart and agreement was reached, and then all of a sudden the sale got cancelled. Well, it's unlikely that you're going to get an Apple anything for under probably about 10 grand, and probably most people know that. So in terms of the common law, where an item, where a consumer can be, you would reasonably know what price to expect for an item. So when you see the price advertised at far greater discount, it's likely that there's probably an error there. As in this example, well, the example there, an item that would ordinarily sell for 3,999 is unlikely to be being sold at 3.99 Rand. And we've had quite a number of complaints where, in fact, items are advertised for 0. And complainants come to us and say, oh, they saw this item on the website and it was being advertised for 0, and now the supplier won't give it to us. Well, the chances are there's been a mistake there. So in instances like that, we term that, well, in terms of the common law, that's referred to as snatching a bargain. So the consumer will not have a leg to stand on to claim the advertised price of 0 or $3.99 in the case of this example.
Yes, basically a reasonable person would think, but this is not possible. From 3,999 to 399, unless it's a very nice, I don't know, Black Friday thing. But yeah, so the common law does deal with that issue where really a reasonable person would see that this is definitely an error. But we do get a lot of complaints, like Nikki said, where consumers saw an advert for 0 and that was 10,000, and they want the supplier to provide the item at that price. And obviously, we have to dismiss the matter, or the supplier would be allowed to say no to the issue. Actually, we do keep a record of the amount of money that consumers claim when they lodge complaints with us. In the period that I reported in terms of the complaints dashboard, the claims that were put in were amounting to 60 million, and we were able to agree on 10 million. So it doesn't mean that some have gone further. But it does show that sometimes consumers can be unreasonable in their claims. I mean, one of the areas where we receive claims that are not reasonable, somebody will buy a packet of chips and say they found a cockroach in the packet of chips, and they want 150,000 for trauma. So yeah. Those are some of the things that we receive. So we always say consumers also need to be responsible, to be fair, just as much as suppliers need to be. So we have come to the end of the questions that we wanted to go through today. Like I said, we are going to continue with this, and we hope that you found it useful. We do get a lot of questions and of unique issues that arise out of the cases that we deal with. So in the next webinar, we will be looking at the following issues, and you are welcome even today to post and let us know which questions you want us to deal with. Some are quite complex, and in some instances we will have to look at getting legal advice. But yeah, so one of the issues that we will deal with in the next webinar is that we get a lot of complaints relating to defective mattresses, and a lot of suppliers are then saying that if the mattress has a stain on it, then it voids the warranty. So the question here is that, is a stain a defect, or is it an issue that should void the warranty? We will look at that. Is it lawful not to give a warranty for a component sale? So if you are selling parts or anything for goods, are those protected and under the 6-month warranty or the 3-month warranty post-repair provisions of the CPA? Issues around a product has a 24 months warranty. However, to qualify for the other year, a consumer needs to register online with the manufacturer. Customers feel that they are being robbed as this is not explained at the point of sale. At what point is a business allowed to charge a handling fee? When a customer returns a faulty item within 14 days, but no box packaging, are we still allowed to accept the item, considering that all required accessories are included with no visible, our suppliers insist on packaging or else we do not get credit. And this was one from a small businessman who said, I provide an online retailer with goods to sell. A consumer made a purchase online and have returned the unit after removing the unit from its packaging, and seals have used the unit and then decided to return it. This is a violation of the terms and also the Consumer Protection Act. the goods were returned not in the original unopened condition, not just unopened. The unit has since been used. The CPA does cover circumstances under which handling charges can be charged, under circumstances under which suppliers can require the goods to be returned in their packaging. So in the next webinar, we will deal with all these questions. And if there are any other questions, you are welcome to post them or contact OMA, and we will try and answer them in the next webinar or other following webinars, because we don't want to bombard you with a lot of information. Thank you. I think at this point, we will take questions.
Yes, thank you, Makhautsa and Nikki. And yes, I've identified Mr. Njoko Bongani. Your hand is up, and we have other questions that were posted on the chat box. We will go through them before we end the session. Bongani, I'm handing the microphone to you to pose your questions. Then I will get to chat box questions. Thank you.
Okay, thank you for that. Good day, colleagues. I've got two questions pertaining to an invoice or a slip. In the event whereby the consumer has lost the slip, but he actually purchased the goods on account or is using a bank account, what is your position in that regard? The second question, the consumer purchases something which actually get defective within 7 days and goes back to the supplier and wants his refund. But the supplier actually said he must wait for the goods to be sold before he can actually get his money back. And the consumer doesn't want the product back. He wants refund. Thank you. I don't know whether you got those two questions.
We got them. Thank you.
Thank you.
We actually discussed this issue about where till slips are lost and cannot be found. And our view was that, look, there are stores that are very customer friendly, and as part of their customer retention strategy, will find other ways to identify the transaction or get a record of that transaction. Obviously, where that is possible, we encourage it, but the CPA is silent on that issue. But our view is that it's not obligatory, but we encourage suppliers where possible and where there are other means to identify the transaction for them to do so. I think it's just good customer care. Nikki?
Thank you. I would say that, and I think Penny's actually raised this question. I saw it popping up. If a consumer has bought goods with a bank card and brings their bank statement and it says XY store of whatever amount, I don't think that suffices, because it's not a till slip and it doesn't prove that you bought that item from that specific item. But it is an interesting question, goods on account. I think possibly it wouldn't satisfy as being a till slip, but if you have a store account and it details what item you bought on what date, and this is the item you've brought in, and it can be proved, I would say that possibly could tend to suffice, because the till slip is really proof of purchase. So if the goods were purchased on account and you can prove it, I think that would suffice in my view. I don't think a bank statement does.
Okay.
Yeah. Okay, and then on the issue of defective goods, where an item is defective within the 6 months implied warranty in the CPA, the consumer is entitled to a repair, a refund, or a replacement. They choose. The supplier does not dictate, the Act does not allow the supplier to dictate what remedy they would give the consumer if the goods are defective. So there, the consumer has the right to say, I want a refund, I want my money back, or a replacement, or please go and repair. But the supplier cannot dictate and say, we only do this. No, that is not up to the supplier. Only in change of mind instances would the supplier have the liberty to then come up with their own refund and replacement policy. Nikki?
Yes, I agree with that. I think in the example that was given, there can be no terms and conditions as to when the supplier is going to refund, if or when. If the goods are defective within 6 months and a complainant wants a refund, they're entitled to it.
Thank you very much, Nikki and Makhauta.
Okay.
Thank you, Bongani.
Thank you very much for that.
Okay. We've got another question here, Makhauta and Nikki, from the chat box, which was raised by Ibrahim. He says, if the CGSO says the implied warranty is 6 months, how is it then possible that queries are entertained a year later by your body and the consumer states that in their case, will it then be fair in the business of a supplier? I think I'm reading it well, but that is the question from Ibrahim. Why are we entertaining cases which are beyond six months implied warranty as the CGSO?
Okay, thank you. Remember that the implied warranty is in addition to any other manufacturer warranty that was provided to the consumer. So, and the second issue is that in terms of our jurisdictional limits, remember that there is prescription, and the way that prescription is defined in our code is sometimes not 3 years since the matter occurred, but since the consumer reasonably became aware of the issue. So we do assess timeframes in terms of prescription, and where we find that the matter has prescribed, we will reject the matter, but we are required by the code to look at the merits and the circumstances around the case. Nikki, do you have anything to add there?
No, I think that covers it.
Thank you.
Thank you. Thank you, Nikki and Makhauta. Luyolo is asking here from the chat box, for cancelled lay-bys by the supplier due to consumer failing to finish the lay-by within the stipulated period, how long should the supplier take to pay back the deposit amount which was withheld at initiation of the lay-by?
Okay, some questions. We will have to note them for the next webinar. Nikki, do you have an answer for that one?
Not offhand. I'm quickly checking the regulations, but I don't know offhand. I have to double check the regulations. I don't think a time limit is stipulated, but I would imagine it probably around about cancellation at times, sort of not, I'll give you your money back in 6 months' time, or when I get the money, because the money should probably ideally not have been spent. It's because it is, I think.
Because I think the Act deals with instances where the consumer cancels the transaction, but I'm not sure if it deals with instances where the consumer then doesn't pay the full amount for the lay-by goods.
Well, Section 62 actually does say that each amount paid by the consumer to the supplier remains the property of the consumer until the goods have been delivered. So my answer, without looking at the regulations, would be that the amount should be repaid upon cancellation, because it is actually, whilst the money's been handed to the supplier, it's still the consumer's property. So there should, strictly speaking, be no excuse on the part of the supplier to say, well, I don't have your money, because it's
yeah, but I hear here that also, the supplier is also sitting with a burden where they are sitting with goods that they cannot sell, and this consumer is not coming back to finalize the transaction and pay the balance. So what are the rights of the supplier in this instance? I think we will record that question and answer it in the next webinar.
Definitely. While we are on lay-by, I see here Crosby is asking, based on section 62 also there, ladies, on lay-by agreements, a 1% cancellation is just. Can a supplier charge an additional administration fee? What
No.
is a just admin fee?
No, the Act provides just for that 1% cancellation. We know it's quite a small amount, but unfortunately that is currently how it is. Nikki?
Yeah, I agree with you.
Okay, thank you, ladies. I see here Crosby is also asking, in terms of pre-owned items, it's seen and inspected by the customer in store to inspect goods. Does the customer have the right to return when it is clearly outlined to examine before purchase and delivery?
The 6-month implied warranty does not apply where the consumer was informed of any defects in the product and they agreed to buy the product as per the defects that they were pointed out to them. For example, some of us shop in factory shop and they will put a little thing to show you that there's a defect here. And if you buy it like that, then you have no leg to stand on to return it unless there are defects that were not disclosed that became apparent to the consumer after they took delivery. Nikki?
I think that's correct, yes.
Thank you. While we are on that defective goods, Ibrahim is also asking, defective part, especially on big ticket items, rules, terms, conditions are in place by the supplier. Before receiving the item from delivery of drivers, it needs to be checked, as disputes cannot be entertained thereafter, as it is merely he said, she said type of a thing. Because the consumer reluctantly checks the item, how then can a supplier be responsible? Also, a major issue in the retail space, consumer allow minors or elderly people to receive the item and disputes to arise, including third parties. Your way in there, ladies?
That's a long question. I think we will reserve that one for our next webinar. But yeah, the fact that my helper received the goods, they are not the consumer in that instance. So if I come home and I inspect and I find that there is a problem, I do have the right to go back to the supplier to say the goods were not okay. Nikki?
I think we should look into this and consider it.
Yeah, no, I'm answering a part of the question, but the detail of it around components, I think we had listed it on the next webinar. We will look at it. Thank you so much.
Thank you, ladies. We've got another one here from Irene. There's a store that whenever there are promotions, they don't take out the goods and will sell it afterwards during normal price. The workers confirm that the products are at the back and we can see the trucks offloading.
That is your typical bait marketing. So you advertise discounted goods, but when consumers try and buy them, they are not available. You then point them to buying something else. So that would require an investigation. And please, people do note that the CGSO is not an investigative body. We mediate disputes between two willing parties. So if there's a crook involved in the process, that would require an investigation by the National Consumer Commission. And then they also only have the right to then escalate to the Consumer Tribunal. Because we do get, consumers get frustrated and say, why is the CGSO allowing this to happen? We are not allowing anything to happen. We are an alternative dispute resolution body mediating disputes between two parties who are willing to come to an amicable resolution of the complaint. So if somebody is behaving contrary to the CPA and it's part of their conduct to contravene the CPA, then that requires investigation by the NCC. Thank you.
Thank you. We've got another one here from Janine. If a customer buys 1 kg of meat and returns 100 grams of it, saying it was off, but they ate the rest or threw it away, what is the rights of the retailer? Are they expected to refund 1 kg?
Well, the Act says, and we will deal with that, the Act does say that where it was necessary, for example, an apple, for me to know that an apple is okay, for me to find out if there are any issues with an apple, I have to bite it. After I bite it, I find that there's a worm inside, and I have to return the remaining part of the apple to the supplier. The Act allows for that. The Act says that in instances where products are depleted or packaging are opened and it was necessary for the consumer either to bite into it or open it in order to confirm whether it's fit for purpose or it's not defective, then there is no penalty for the consumer. So yeah. So unfortunately, if the meat was indeed rotten and there was a problem, you have to refund the whole amount, because the only way the consumer could find out that the meat is rotten is to eat it. Maybe, yeah, smell it. Nikki?
Yeah, that's, I think Magauta, I understand the question, because it creates suspicion, possibly, just to return 100 grams and where's the other 900, and where's the doctor's note and all the rest. But
Yeah.
probably it's good practice to even though you may have your questions around it, just to refund the kilogram. Personally, if it was me, if I'm sort of cooking something and I can see this isn't going, I'm going to give you what was half cooked, what's left of it, and bring the whole lot back and say, there you go. But not everyone's like that.
But you still remain in the same position as a supplier. You know, whether the half a gram is cooked or not cooked, you still have 900 grams of uncooked meat. But you know, look, consumers do take advantage.
Mm.
And we do look at those issues. I mean, you saw in our outcome that 60% of cases were in favor, and we do have cases that were not upheld. But you know, we are sitting in a webinar now, and we are not looking at the issue. Every issue, you have to sit down and apply your mind and read the Act. So, off the cuff responses, yes, you can take them with a pinch of salt. That is why we said we will have another webinar where we respond to some of the complex issues, because some issues is not a matter of yes or no. You have to look at the evidence, you have to look at the circumstances, you have to interview the supplier, you have to interview the consumer. But yeah, there are certain, the provisions in the Act cannot be taken as is, but they do provide for those instances that sometimes the consumer would have to open the packaging, would have to bite into the apple, would have to eat something, and then they find out that there's something wrong with it. But yes, there is sometimes abuse, and where we identify it, we have to dismiss the matter.
Okay, we have another one here, Nikki and Magauta. Crosby is asking, what is a reasonable term for repairs to be done by the supplier?
The Act says that a consumer is entitled to timely services of the quality that a reasonable person would expect. So that is a contractual issue. So your supplier, that is not prescribed in the Act. The Act says that you are entitled for the services to provide you in a timely manner. The timeliness of it sometimes is a contractual issue between the consumer and the supplier. And then the Act says that where the supplier is not able to provide the services as agreed, or components or parts of the quality that the consumer would expect, then they would have to enter into an alternative arrangement. If not, the consumer is entitled to cancel the agreement and get a full refund. But I think it's something that we can also deal with in future webinars. But basically, there is a requirement for services to be provided as promised. We get a lot of our online complaints is delivery is not on time. So an online supplier will say, I'll deliver to you in 5 days. So if they have said 5 days, the Act says they must deliver in 5 days, or within, if they foresee that they won't be able to deliver in 5 days, they need to communicate with you. And if you don't accept the alternatives, you are allowed to cancel and get a refund. Nikki?
Yes, I agree with that.
Yeah.
Okay, thank you. Another interesting one here says, Mr. Ibrahim, well, on the issue of refunding money on cancellation, from my experience in our enterprise, many of our stores were held up, managers were killed, so the company does not keep cash in store at all. I think he wanted to write that. However, we make the customer aware of a day to collect the cash, or even give an alternative to EFT with correct documentation. Will then a supplier be accountable for a valid reason?
Well, the Act does not prescribe what the refund, how the refund must be processed. So some suppliers, I mean, I've never experienced well, cash, some give cash, and some would say give banking details, and then they will refund into your banking details. But a lot of time we get complaints from consumers to say, if I did not use a card or a credit card or a debit card to pay, why should I suffer the pain of having to wait for them to be able to process through that method which I did not use? So some consumers demand to be refunded through the purchase method that they used. Nikki?
Well, in my experience, when I've tried to return goods, suppliers actually insist on refunding in the same way that the goods were purchased. So, for example, if I paid cash and I want to put on my card, they won't. You get cash back, or it goes back on your card. But that's just my personal experience. But as you said, the Act doesn't prescribe.
Yeah. So they can do that, and the time frames. Some it depends. Some sections of the Act do indicate when within 10 business days or whatever. But for example, your defective goods does not prescribe the time within which the refund should be paid.
Yeah, I think it's section 16, cooling off period for direct marketing. I think it's just,
where a time frame is prescribed.
Yeah.
Mm-hmm.
Perfect. Thank you. We are getting interesting questions here. But I must say, ladies and gentlemen, please allow me to end this session at 12:45. So I'm going to take up the remaining questions. But as we have indicated, all your outstanding questions, we will address them in the next webinar. And you are welcome to email me directly with your other questions that you have. I've got a question here, Nikki and Mahauta, from Aaron Kiston. If a consumer demand transport costs for purchasing a defective item that cost, for an example, 15 rands, keeping in mind that they have been reimbursed twice the value of the product, what then?
Reimburse twice for the value of the product. Yeah. Why would you reimburse twice for the value of the product? So that is entirely up to you, being very friendly. The Act does not require that. If I bought an item worth 60 Rand, the Act says you must give me 60 Rand. So if you want to give me something in addition, nice, but that is entirely up to you, Nikki. So this is a policy issue within the supplier.
Yes, I'm not sure if I understand the question. When the refunded twice, I would have said refund the amount. If the goods are genuinely defective, there's no dispute. Refund the 15 Rand, and yes, refund the petrol, even if the petrol's 100 Rand and the item is 15 Rand. If you've refunded double the value of the item, that's your prerogative. But
or is he calculating the 15 rand plus the product and saying it's double the value of the?
That's not what I'm not sure about. And also on the basis that the consumer's been refunded twice, does that mean that the item got bought and returned because it was defective or replaced, and then the complainant came back and said this now the next one's still defective? I'm not sure. But I think the bottom line would be, even if it's a 15 rand or a 10 rand item, if it's defective and the complainant wants a refund, they're entitled to a refund and their costs insofar as they can quantify them.
Oma, please put up your email address in the chat box. Thank you.
Okay, thank you, will do. Okay, Kirsten, you can also email me so that we can expand on your question. And Crosby here is saying, when a customer purchases goods and is to be ordered with a lead time, but they decide to cancel the order within the lead time, can a supplier reserve the right to charge a handling fee and refund the difference?
Well, if I'm correct, he's referring to special order goods.
Well, not necessarily special, or I don't know. Possibly.
Is it special? Where is it products that are made specifically for the customer?
Yes, in certain instances we'll be out of stock and the customer really wants the good. So we say, okay, we're gonna order it for you. 18 working days, for example, for the manufacturer to produce the good for you. And then they decide, once we've paid the customer, the manufacturer, sorry, the customer decides to cancel the order. Can we reserve the right to charge a handling fee? Because we already paid the supplier the money and the customer is still waiting for the good, but then they decide otherwise.
The Act does treat special order goods differently. The customer has very limited rights when it comes to goods that were specifically made for them or specifically ordered for them. They have to comply. They have to honor the transaction. Nikki?
Yeah, that's correct.
Yeah. Because there you are not just selling it. The person came in and say, I want a specific thing. You are selling a black leather couch. They say, I want a blue one made this way and that way, and it must be ordered specially. Then they cannot get out of that transaction.
Thank you very much.
Thank you. Magauta and Nikki, thank you so much. I see someone is saying they are hungry now. Though Abraham was still saying, I'm disputing your statement that Apple bought and remained in the veg stand, and then consumer decided to take a bite after a few days. How can he prove the worm?
That is why I'm saying you have to look at the circumstances of the case. So obviously we will look at when did the consumer buy the apple? So that is why I say there are no straightforward answers without looking at the case itself and the circumstances surrounding the case. So here we will tell you what the Act says. But when we actually receive the complaint, definitely we will say you bought it 7 days ago. How did you store it? What was happening? So those questions will be asked. So we don't just say section 20 says this and we apply it. No, we look at the merits of the case. And obviously, the fact that it was bought 7 days ago would be a factor that would be looked at when we deal with the complaint.
Thank you. Thank you very much. Ladies and gentlemen, allow me to conclude this session. And I really noticed all the comments where people were saying they've benefited, the session was insightful, and as we are promising that we will have the next webinar of this kind so that we engage. Thank you so much to our Ombudsman, Magauta Mpahlele, and our Complaints Manager, Nikki Stadka. And ladies and gentlemen, thank you for staying with us and engaging in this session. We have also benefited from your input. Thank you so much. I will then declare this session the end. Thank you. Keep well.
Thank you, Oma.
Thank
you, everyone. It was a learning process for us as well. And we really appreciate all the comments and the questions. And like we said, we will continue to engage with you because we learn from you as well, as much as we are imparting information to you. Thank you so much.
Thank you. Have a great day, everyone.
Thank you.
Oma, you said we must stay, ne?
Yes.